So I do want to introduce Yuli. Will present us now privacy training. Actually, it's a startup that he established a few years ago. Yuli is a well-known and known architect, application security in the field of data privacy also for over 15 years. I know him from several years. With a great achievement in cybersecurity in Israel and also abroad. So Yuli, the stage is all yours.
Thank you very much. So I hope my presentation will be not boring. So a few words about myself. I am a security guy. I was doing
Yuli, you can click and go to the next. Yes.
Yeah.
Great.
So I have a security background. I was doing security research, penetration testing, cloud security for quite a few years. I worked in Checkpoint under RSA security and a few other small security startups. During my career, I found a database security company called GreenSQL, which later was renamed to Hexatrial and was sold to Huawei. So we built a product around data security. So this is my background. For the last 2 years, I'm working on a privacy and data security product. So our company name is Privacy Bunker. So and we have several tools. One of them is open source. It's called Data Bunker. During my presentation, we will take a peek at this product as it helps to improve privacy and privacy by design compliance. So let's dive into the privacy. We start with the basic terms. So what is a data subject? Data subject basically is any person that can be identified. It can be your customer, your user, your marketing lead. It can also be your employee. Important point of GDPR is the data subject is a data owner of his own data. When reading privacy-related articles, you will see several data subject-related terms. For example, data subject request, DSR, for example, forget me request. The other term is data subject access request, DSAR. When getting DSAR, you need to send custom data back to the data subject, or basically to your customer. When talking about GDPR, we talk about controllers and processors. GDPR identifies two types of companies. Controllers are the ones that control personal data. They have direct relationship with the customer. Example for controllers, an e-commerce website or bank website. The other types of companies are called processors. Processors process personal data on behalf of controllers. Processor can also be considered controller for its own marketing leads. Example for processing companies are MailChimp, credit card processing companies. One important note is that individuals can bring claims for compensation against both controllers and processors. So any company is in charge for custom data, and everyone should treat custom data with security in mind. Sorry. So when talking about GDPR, we have very important topic is PII. PII is basically personal identifiable information. It is any information that helps to identify a customer. We have strong identities and weak identities. Strong identity, for example, a username, email address, telephone number, or social security number. Weak identity is identity, which by itself does not tells us who is a user, but a combination of weak identities helps us to identify a user. For example, browser information, browser version, IP address, cookie name, or mobile device location. Like in triangulation, a combination of weak identities can lead us to a user. Strong and weak identities are all considered PII. All PII processed in your organization must be treated in secure manner. Companies are processing personal data using various methods. Processing is basically any operation which happens with the data. Generating list of customers, storage of data in a database, fraud analysis, sending out emails, shredding documents, image processing, saving in audit log everything is considered personal data processing. In order to be able to process personal data, companies need to have a legal basis for this. The GDPR identifies 6 legal bases to process personal data. The consent legal basis can be in a formal checkbox displayed on a sign-up page or in cookie pop-up. Contract legal basis is when you have a contract with a customer. For example, in GDPR, terms of service and privacy policy are also treated as contracts. Legal obligation legal basis is when you need to keep a log of payment details. Vital interest legal basis is when you need to keep vital interest legal basis is when processing is necessary to protect someone's life. Public task legal basis is when processing is necessary to perform in public interest, for example, a scientific research. Legitimate interest legal basis is when processing is necessary, for example, to fight with fraud or network security. Processing for direct marketing can also be considered under legitimate interest. So consult with your lawyer before you want to process personal data. In order to comply with GDPR, companies need to follow 7 key principles when processing personal data. The principle of lawfulness, fairness, transparency tells us the following. Companies must have legal basis for personal data processing. Personal data should be used in a fair way and not misleading or unlawful. Companies must have a clear, open, and honest with people from the start about how they were going to use personal data. Companies must not deceive people from collecting their personal data. The purpose limitation principle tells companies to display clearly what is the purpose of processing of personal data and do not change it afterwards. For the accuracy principle, companies must take reasonable steps to ensure that personal data is accurate and is up to date. The integrity and confidentiality principle tells the companies must have a proper security controls to ensure unauthorized and unlawful access is blocked. The accountability principle is as following. Companies must have appropriate measures and records in place to be able to demonstrate compliance. For example, by demonstrating and implementing privacy by design. The storage limitation principle tells the companies must not keep personal data for longer than they need it. Data minimization principle tells that data must be adequate, relevant, and limited to what is actually required. Let's take a look at data minimization as it becoming one of important topics. The result of data minimization is companies must remove personal records for expired trial users or users who left the company service. Take a look at this example. You see an email received by a job candidate from GitHub. GitHub tells the candidate that his personal data will be removed in 30 days. The candidate can leave his details by pressing Keep My Data, or his personal data will be automatically removed in 30 days. So this is what expected by the data minimization. Companies must remove personal data without waiting data subject removal request from the customer. So-called data subject forget me request, it's called. Let's take a look at the following example. Deutsche Wohnen SE is a German property company. They had to take their chance in a court and pay a hefty lawyer's fee in order to avoid 14 million euros fine imposed by German Data Protection Authority. The fine was over retention of personal data. Deutsche Wohnen is $11 billion euro company, so it's a big company, and for small companies you need to follow the rule. You don't to delete customer data. Privacy by design. When creating companies and business processes, privacy by design is one of the most important aspects of personal data. You should make user privacy to be one of your top priorities. You need to address privacy risk in a proactive manner. Security controls must be in place to ensure unauthorized access is blocked. Your customer should not have to do anything to ensure that the data is safe. You have to integrate data integrity and data protection into processing activities and business practices. My team maintains an open source project called Data Bunker. This product can easily improve privacy by design compliance for your company. You can take it, it's open source, or you can take a proper Data Bunker Pro that is also available. One has been fined for almost 10 million euros. The company was failing to comply with GDPR requirements. Callers to its call center could obtain customer information by simply providing a customer name and date of birth, and this was not in compliance with GDPR Article 32, and the company was fined for almost 10 million euros. GDPR introduced a number of user rights. Users have the right to be informed about how the personal data is used. For that, you need to update personal data, you need to update privacy policy and terms of service. Right of access gives your users the right to obtain a copy of their personal data as well as supplementary information. Right of rectification gives your customers the right to fix incorrect or incomplete personal data about themselves. The right to erasure or right to forget me. Today, everyone knows what is it. Right of data portability gives the customers possibility to obtain and reuse their data in another company. So basically, you need to provide your customers with a JSON. Right to object. Your customers have the right to file an objection. The last right is related to automated decision making, including profiling. What it implies is that companies can request human intervention when their processing performed by artificial intelligence, for example. Pseudonymization is a term coined by GDPR. It is a hot topic. Pseudonymization is a security solution to process personal data in many situations. GDPR defines pseudonymization as following. Pseudonymization means the processing of personal data in such a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information, provided that such additional information is kept separately and is subject to technical and organizational measures to ensure that the personal data are not attributed to identified or identifiable natural person. So how to make it work? You can take user personal data and store it in data bunker. Data bunker encrypts personal data and generates a random user token. This token is basically pseudonymized user identity. You can use this user identity, for example, in your web application logs or in external database or in cloud, and it's compliant with GDPR. I'm getting a lot of, my users ask me the same question all the time. How are they going to use, how are they going to make their logs GDPR compliant? So it's tricky, and I will tell you exactly what to do. There are no specific requirements for storing logs except for the generic ones. For example, customer and data security. Another important aspect for log storage is compliance with user forget-me requests. When getting forget-me request, you need to remove user details from the log files too. It can be a challenging task that can be simplified. According to GDPR, you have 1 month to respond to user forget-me request. So if your log retention period is just 1 month, you do not have to do anything. Your customer details will be automatically removed. The second method is to use pseudonymized user identity. For example, the one generated by data bunker. Instead of saving your user details in clear text in your application logs. Another solution is to encrypt personal data in log files. The last alternative is to manually remove log entries in case you got forget-me request from user. Due to government requirements, for example, to keep details of payment transactions, for 5 years, you can keep payment logs unchanged as long as required. Cross-border personal data transfer becoming as very important, especially with the invalidation of Privacy Shield framework. This framework was used by 5,000 US companies to conduct transatlantic trade in compliance with EU data protection rules. The reason behind this decision is that current level of protection given to personal data under US law cannot be considered to be the same provided by the European Union. This is largely due to US surveillance programs. Today, you have a number of solutions to do cross-border transfer. The first is to use standard contractual clauses, also known as model clauses. It means your users need to approve for their personal data to be processed abroad, for example, in US. Another solution is to use European Data Protection Board guidelines, published in 2020. This document detailed a number of technical solutions to cross-border transfer. One of the methods is pseudonymization, covered before. According to GDPR, you have 72 hours to report a security vulnerability. Sometimes you need to report to individual users, to the victims. Consult with the lawyers before. Twitter was fined for almost half a million euros for not compliant with this law. They took more time to report the security vulnerability. The next topic is cookie consent. You will see cookie pop-ups almost on any website these days. You cannot set tracking or advertising or not essential cookies on your website visitor before your visitor gives his explicit consent. Your visitors should have a means to enable or disable non-essential cookies. Some companies go to another route, for example, GitHub has done. They completely removed all third-party JavaScript from their website. As a result, they do not have to display any cookie banner on their website. They only have required cookies to work on. In this case, you do not need to show any cookie pop-up. Just a second. Okay, this one. Optional categories should be disabled by default. In the screen, you see a cookie settings window where advertising analytics categories are disabled. This is a requirement for GDPR. Google was fined for almost 44 pounds for not compliance with this law. Google had to obtain a clear consent to process personal data for ads personalization. Option to personal ads were pre-ticked when created an account, which did not respect GDPR rules. In California, we have CCPA and GDPR in Europe. What is the difference? So CCPA is much lighter version. It's for big companies mostly. The biggest difference with GDPR is in GDPR, companies have a prior consent before personal data can be processed, for example, sold. Customers need to give their explicit consent. And in CCPA, companies can sell customer data without getting customer consent. The customer can tell the company to stop selling their data, but they couldn't do it. But the customer data at this point can be already sold. In addition, in GDPR, we have 6 legal bases. In CPA, we do not have this. Okay, guys, before before to go into the demo, let me check the comments.
So guys, if you have any questions to Yuli, please ask in the chat. We will answer. I don't think there is any, but guys, if you have any questions, please write them down in the chat. So Yuli will be able to respond back. If not, let's continue with the demo, Yuli.
Sure. Just. Can you return? Okay, so this is a Data Banker website. I am so Data Banker is a program that can be used to store customer data. The companies can take the user JSON object and store it in Data Banker. Data Banker encrypts the customer data and provides a secure solution for customer data storage. It provides an API, so this product can work together, for example, as a backbone, as additional data, a database for your project. You can connect it, for example, from GraphQL to this tool as well. So let me show how it works. So this, you see here, customer profile. The custom details can be changed here. For example, I will change my name. I can click on save. Oops, got disconnected. So in the demo, we have the same username. It is the user phone is 4 times 4 times 4, and the code is 4 times 4, the same code. Okay, so this is my profile. I want to change here my first name, for example, to comply with data rectification GDPR requirements. So I type my name here and click on save. The product saves this change. This change can be made in compliance with the company flow. For example, a DPO admin will get an email telling that the user has changed his details. After, I can go to the history screen to see any operation which happened with my account as a user. For example, I can click here, and I can see that my details was changed. For example, I changed my first name from testing something to Yuli, which is because I'm Yuli. So I performs data rectification operation instantly. In addition, application profile data, I can save additional application data, for example, shipping information. And the next screen is my agreements, where I can manage all consent or contracts that I sign in for the company. So I can give or withdraw my consent, and everything with a compliance with a company policy, as some operations require data privacy officer approval. So for example, I can give here a consent, and I can also withdraw one, and depending on configuration, data privacy officer will get a notification. My next screen is my request. I can see all operations which require data privacy officer approval. For example, previously I click on forget me, and I see this event. I can also ask for removal. So this event is cancelled. Now I will go as an admin. Admin token is demo, capitalized demo. So I can see here all requests that require data privacy officer approval. So currently I have no user requests. I have processing settings operations, where I can configure what are the processing operations, which we talked previously. For example, selling customer data or integrating a cookie pop-up, and everything can be managed from here. Next screen, audit. Here I can see all operations which happened with personal data in all the system. And this product is built in Go language, so it's very, very fast. It is using a regular SQL in the backend. It works with the PostgreSQL or MySQL or SQLite. Also, I have a Data Banker Pro version, which gives better control in terms of customer data. The user can manage customer data in different third-party services, for example, in MailChimp, GetResponse, HubSpot, Salesforce, using one unified management portal. So this tool is also great for data privacy officer because they do not have to wait for IT guys to execute a user request. Everything can be done using this tool, and it works instantly. And the open source version is available on GitHub. You're welcome to download it. Guys, do you have any questions?
Okay. If you have any questions, please write them down in the chat. For Yuli or any other, please feel free to write questions. Okay, so as Yuli said, his product is actually online. You can download it or use it for free, and there is also, I think, license mode also if you need. So you can download the freeware and also with the license one. So is there any questions, guys? If you have any questions to Yuli regarding his presentation or any other question regarding data privacy, please feel free to ask. Okay, I know that some people ask regarding the presentation. So we are uploading all our presentation and recorded session to our group member page in the meetup.com. It's also online, will be on YouTube and other channels. So you will be able to see also the presentation and the recorded session. And of course, if you need to get in touch with Yuli, here is his details. But as I mentioned, all the presentation will be uploaded to our website, our meetup page. Guys, if you don't have any questions, last minute questions to Yuli. Okay. Okay, so I think we can wrap up. So thank you very much, Yuli, for your presentation. Very insightful. I think most of the people are starting to understand what they need to do in data privacy. They need to learn more about data privacy and how to protect it. And of course, there should be adapted to each and every product. If you are using it in your company, using a third party, or even developed your own product. So you need to keep that in mind, how you manage private data, how you are keeping that, how you are preventing it to being leaked to others, of course, and also how you keep private data because of the new regulation. As Yuli said, the GDPR is the General Data Protection Regulation in Europe for Europe citizens, and there is also the regulation, the California Act in the US, but actually the data privacy regulation is being developed and written in each and every country. So you have in German, and I heard that there is in the Philippines and also in other countries. So each and every country, also in Israel, we have our own private laws. So we need to be aligned with this law and protect data, protect private data. Okay, so guys, thank you very much. Thank you very much for all the lecturers, Manny and Alex and Yuli. Thank you very much, guys. Thank you very much all for participation. If you have any further questions, feel free to ask directly the lecturers. You have their emails. You can also subscribe to our meetup page and ask there more questions. And looking forward to our next meetup. Hopefully next month. So see you there. Keep safe, guys. Keep well, keep safe, be healthy.
Thank you, Lior.
Thank you very much. Bye for now. Bye-bye all. Thank you,
for
Yuli.
great work.
Thank you very much, guys.
Bye-bye, guys. Thank you.
Bye for now. Thank you very much.